So, okay. Yeah, so very good evening to all of you. Thank you for joining us today on this webinar on courts after COVID. I'm Sandhya from DAKSH. DAKSH is a civil society organization. We undertake research on access to justice and judicial reforms. This webinar today will focus on the challenges that the judiciary has faced in the wake of the pandemic. The judiciary has, of course, done wonderfully well to rise to this challenge. We've engaged very well with technology, I would say, whether it is video conferencing or e-filing. So in this context, we will be focusing on certain discussion topics and exchanging ideas on certain changes that have happened during the lockdown. And of course, we are looking towards reopening of the courts as well. So an important aspect of our discussion would be framed in the context of what do we take forward when the courts reopen for physical hearings, and what protocol, I mean, considering the protocol that we need to follow with social distancing and the other restrictions that are in place, what more can the courts do as well? So before I initiate the discussion, I would first of all like to extend a very warm welcome to our two distinguished panelists today. We have with us firstly Justice A.V. Chandrashekhara. Very warm welcome to you, sir. Justice Chandrashekhara has served as a district and sessions judge. He was elevated to the Karnataka High Court in 2013. He's well known for his swift disposal of cases. Post his retirement, he's been an acclaimed arbitrator. He shares a very strong inclination for the usage of alternative dispute resolution mechanisms in the justice delivery system. And he's also a resource person with the Karnataka Judicial Academy. He served as a director of the Karnataka Judicial Academy for over 2 years. And he was also a judicial member of the Karnataka Administrative Tribunal. He's written a lot of articles on the administrative issues that plague the trial courts. Our next panelist is Dhruti Kapadia. Dhruti, welcome Dhruti. Dhruti is a solicitor, arbitrator, and advocate on record, Supreme Court of India. Dhruti has a wide range of practice covering civil, criminal, commercial, and technology law as well. Dhruti is also empaneled with the Mumbai Municipal Corporation. She's also part of the state legal aid wing. Dhruti is an author. She's also a professor of law. And Dhruti has written a lot of articles for established journals and newspapers. So I extend a very warm welcome to both our panelists today. Before I move on to the discussion, I would request our panelists to make some opening remarks. Justice Chandrashekhara.
A very good evening to all the viewers and the learned panelist, Ms. Dhruti. COVID-19 is a great pandemic. Extraordinary situations require extraordinary measures. Judiciary also requires extraordinary measures. We have seen that courts have not been functioning for more than 45 days, and we do not know when the courts return to normalcy. It appears as though we will have to live with this COVID for quite a long time. Keeping this in mind, we have to suggest some good remedies, good steps to be taken by the judiciary to face the problems. Lawyers are inevitable part of judiciary. They are addressed as officers of the court. They too have a great responsibility in ensuring that court proceedings, both during the lockdown period and the post-lockdown period, function in a very smooth manner without damaging the health of the judiciary, which means the health of the judges, the health of the lawyers, the health of the litigants, and the health of the innumerable staff working in courts. We have constitutional courts on the one side, which do not record evidence except in few cases, like the election petition cases, and the trial courts who take up the responsibility of recording evidence and disposing of cases. We will have to think the steps to be taken in different dimensions. In this regard, this webinar, I'm confident, will play a great role. We are not here to find fault with the judiciary as a whole. We are here to support it. I'm confident, as a former judge of the High Court, I know very well that Karnataka judiciary, especially the High Court, is taking a lot of steps to see that courts open in a staggered manner and then return to normalcy. Judges are waiting, anxiously waiting to work. They are also conscious of various impacts of this COVID, and I think this would be a step in aid towards judiciary which is facing a lot of challenges. I am very confident that my co-panelist, Ms. Dhruti, will also be of great help in suggesting some good remedies which can be taken into consideration. Thank you.
Good evening, one and all. It's my pleasure and privilege to be on this panel, especially with the virtual meet with Justice Chandrashekhara. It's a privilege, and I must compliment and congratulate Daksh for having this organized. I would like to start with one important quote, which is very dear and near to me. Education is the most powerful weapon which can be used to change the world, as said by Nelson Mandela. So today, we have to educate ourselves with technology because we want to move forward. In this COVID-19 situation, we know we are hellbound to be home. We don't want to be home. We want to go out and work. But is our work stopping? Work is not going to stop. The matters are pending. It's heavy in nature that we need to keep moving. But how do we do that? So virtual court hearings is an open way and a most acceptable option for us to move forward and make sure that everybody gets work. Maybe not to a higher extent, but in a baby step method. Let's start beginning. And I'm glad I'm here and I can put my inputs and suggestions to everyone here. Taking it forward with Sandhya ji, can proceed. Yeah.
Yeah, so just a note for our audience members who are viewing this live before I start the discussion. So if you have any questions, you can post them as comments while you're watching YouTube video. So once it comes as comments, we can all see that as well. It simultaneously reflects on our interface. So if there are any questions that will be addressed at the end of the webinar, once the discussions are over. So that's just a note for the audience to bear in mind. That being said, I'll initiate the discussion for today's webinar. The first point of discussion that I want to bring here is the role of alternative dispute resolution in easing the backlog of the cases. So we all know that we lost a lot of working time in this shutdown. So how do we, there are two aspects to it. One, how do we ensure that we use ADR in a way to reduce dependency? And number two, we all know that the lawyers have also lost a lot of work opportunity in this amidst this shutdown. So how do we ensure that we can leverage areas so the lawyers can also be involved in this process and they can also have a steady flow of work? So this is the first discussion point. Justice Chandrashekhara.
Now, as rightly pointed out by Ms. Dhruti, a lot of cases are pending in the trial courts and the high courts. Then comes the prioritization of cases in the background of the lockdown being still in vogue. And in a few days, lockdown may be eased. First of all, alternative dispute resolution mechanism is one important means to reduce dependency. As all of you know, Section 89 has come into effect from 1/7/2002, and Section 89 mandates that all the judges dealing with civil suits, that original courts, must persuade the parties before them to opt for one of the modes of alternative dispute resolution mechanism, that is arbitration, conciliation, mediation, and Lok Adalat. Arbitration, as you know, it is relevant only in few cases like the big contracts where huge accounts are involved. Even if arbitration is resorted to, the award is amenable for challenge under Section 34 of Arbitration and Conciliation Act initially, and then under Section 37 before the High Court. There is no finality. It may be acceptable in only a few cases. So far as conciliation is concerned, conciliation, mediation, they are identical except to the extent that a conciliator has the freedom of suggesting the terms of settlement and pushing the parties gently to a settlement. But a mediator can't do it. He can only allow the parties to generate options by themselves and choose the best option which is applicable for their dispute. So far as Lok Adalat is concerned, it has gained a lot of importance, especially in cases which do not involve serious questions of law and facts. You know, large number of cases, motor accident claims cases, check bounce cases, cases pertaining to eviction are being dealt with on a day-to-day basis in Lok Adalat, and there has been a substantial disposal under the Legal Services Authorities Act. Mediation, as you know, presence of parties and all those persons who help the parties to enter into an amicable settlement are required. And in the present scenario, mediation may not be the proper means till most of the restrictions are eased, because when parties are to come, it is very difficult to ensure social distancing and other safety measures in a small hall. Therefore, it would be difficult in few cases where the parties are very, very limited in number, where other persons' presence is not required. Mediation may be resorted to, and mediation I consider as one of the best means where personal relationship is involved. All family matters, they are the best matters to be referred to mediation. Lok Adalat in the present circumstances is the best method. Motor accident claims tribunals, pre-Lok Adalat sittings could be held with the help of the lawyers. Lawyers who have good number of cases can be called, and their cases can be taken up in pre-Lok Adalat meetings, and there a consensus can be arrived at, and then regular Lok Adalats can be organized, and if parties' presence is required in such cases, they can be called. And check bounces cases, you know, after there are large number of check bounce cases pending in various courts. In Karnataka itself, I think 2.75 lakhs to 3 lakh cases are pending. Most of the cases, and parties know very well that they do not have much defense in view of the presumption available under Section 138 of the Negotiable Instruments Act. And the lawyers representing most of the accused also know that they have a limited defense, and many a times they are the best cases suited to be settled in Lok Adalat. And Honorable Justice Ravindran, in his eloquent judgment rendered in Afghan Infrastructures case 2010, 8th volume 24, has said that check bounce cases, MBC cases are the best suited cases for Lok Adalat. And I think our judges, and I am given to understand that Karnataka State Legal Services Authority has been interacting with all the principal district judges and the other stakeholders to formulate appropriate action plan during this lockdown period, as also post-lockdown period, for settlement of such cases in Lok Adalats. And then small cases where parties' presence is not necessarily required. Those cases can be definitely mentioned to the registry of the High Court or the trial courts, and they can be taken up, and time slots could be provided so that those cases are taken up only during that time slot. For example, trial court 11 to 12, all bail application cases. Say few bail application cases, 12 to 1. Some cases in which injunction is required, stay orders are required, or some urgent hearing is required. And from say 1 to 2, 4 or 5 other cases where some small evidence will have to be recorded, partially heard cases, they can be taken up. In the afternoon, some cases of final hearing, 1 or 2 cases, and only those lawyers will come. So, in the initially for 2 or 3 months, more number of cases should not be listed. Very few cases must be listed, and only lawyers who have cases, listed cases before the courts, must be allowed to come near the court hall. And also one of the suggestions
I
is,
think,
let us assume that yes.
I think, sir, I think this could be more specifically covered when we discuss listing a little later on as well. So,
Yes, yes.
that's an important point. So how do we manage and ensure that listing is made efficient? So, Dhruti, your thoughts on the ADR issue?
Yes, I will put in a very positive thought to this effect that it is time now to take ADR very seriously. That is alternative dispute resolution. But now you will ask me, how do we do ADR when courts are not going to work? We are not able to meet. So online ODR, that is online dispute resolution, would be a good mechanism. EADR is another mechanism which they give a substitute word to ODR, where alternative dispute resolutions can be resolved. And how do we do that? With the push and encouragement from the bar associations and from the bar councils in consonance with the guidelines set out by chief justices. Obviously, if that is possible, then many lawyers who are trained arbitrators and trained mediators would get opportunities to work forward and also change their mindset while they advise to their clients, look, let's not litigate. There is a possibility to settle the matter. Why not avail the option of mediation? Why not avail the option of arbitration if it can happen virtually? Many a times when clients come to us, we always look at the folly of the client's case and say, look, it's better not to litigate or to litigate. We advise them accordingly. So why not change our mindset to advise them rightly by saying, look, there is a possibility of negotiation, a possibility of conciliation, a possibility of mediation, because that will keep us getting work. That will not tell the clients that court is shut, the door is not open right now for everybody to go there because of social distancing maintenance. And secondly, the clients will also sometimes benefit if the matter is settled in a short run, because litigations is really pending. We have to make a way out of that pendency also to make sure that even the court is not overburdened. We already have court annex mediations, we have empaneled mediators in Bombay also. But why not have private ADRs, online ADRs options also available, which many countries abroad have it. So lawyers will not really be workless. The only thing is they have to train themselves. There are many online courses. If they start taking up, they definitely will get the base idea of it, and things can of us. That's it that I would like to say on this.
Yeah. Also, I think the next issue is prioritizing cases. I think Justice Chandrashekhara had mentioned it while he was responding with the ADR question as well. So how do we best prioritize cases, especially because, because of the lockdown, you have some lockdown-induced cases as well. Now you're going to have more number of cases and we've also lost work time. So how do we best prioritize cases? Is video conferencing going to make a big difference in that prioritization of cases? Justice Chandrasekhara?
In fact, Karnataka civil case management, civil courts management rules have been in existence, have been in work from 2005. But for various reasons, especially during this lockdown period, the judges have not been able to implement it effectively. But while taking the aspect of prioritization of cases, we'll have to keep in mind prioritization of cases in both the high courts and the trial court. Let us go first to the trial courts. Trial courts, I think that cases in which partial arguments have already been heard, they could be taken up. Cases in which almost 90% of the evidence is recorded, few witnesses who need to be examined, those cases are taken up and listed well in advance with the consent of the lawyers. Because some lawyers may be 60 plus, and some may be having some comorbidities also. Some exemptions will have to be given, and those who are not able to come and those who do not like to come for good reasons, they must be exempted, and after taking consent, such cases must be listed. And other cases where the presence of the parties are not required, only lawyers can deal with this case. For example, hearing interlocutory applications, and then miscellaneous appeals in the trial court, another miscellaneous cases, and framing of charges via video conference, and then this remand through VC till the framing of charges and fixing dates for trial. A lot of cases are there. These cases could be definitely taken up in the trial court, both on the civil and criminal side. And for example, even in Ms. Dhruti is right in suggesting that we must popularize this ADR to the maximum extent possible, because according to me, not even 20% of the most of motor accident claims cases are fit to be decided by judges after recording evidence. Most of them can be decided by in Lok Adalats, because there are no intricate questions of law and facts, and all aspects of law have been settled by the Supreme Court, both in terms of Sarala Verma case or Pranay Sethi case and everything. Therefore, lawyers may be persuaded to say, to give their opinion vis-a-vis the opinion of the insurance company, and come to a proper understanding and then decide cases. And this will be of great assistance. And one suggestion is, before the lockdown, lot of amount has been deposited by the insurance companies towards the awards passed by the MACDs. They need to be released. They must also be given priority so that the parties will get their legitimate dues because of awards, and lawyers will also get their legitimate fees from their clients. Similarly, a lot of amount is pending in respect of execution cases arising out of land acquisition compensation cases. They can also be decided. Execution cases where the presence of parties are not required, they can be taken up. And all cases where the presence of parties is not required and where some urgency is found, they could be notified with the consent of the parties for few months.
Okay.
Insofar as High Court is concerned, Madam Sandhya, all you know very well that there are admission cases waiting for quite a long time. They'll need to be admitted. Some orders like injunction will have to be passed. Some stay orders will have to be passed. They can be taken up in time slot, and lawyers, if possible, can argue from through video conference also. If lockdown restrictions are eased, few lawyers can come. And even filing also, Karnataka has brought out a model. Karnataka High Court has brought out a model, and yesterday 182 advocates had listed for filing cases, and they were allowed. A rain-proof Shamiana is put up, all the social distancing is maintained, they will file, and the moment they file, on the presentation forum itself, an endorsement would be given. And we have made suggestions to the High Court also to see that the objections are sent through email to the concerned advocates, so that they will know what objections they will have to comply with, and once for all they will comply all the objections. Every now and then they need not go to the office, ascertain those objections and come back and then comply. And thus the entry of the advocates in the court rooms, in the offices of the courts will also be avoided. I think this Karnataka High Court is making, and I'm very happy to know that senior judges of the Karnataka High Court have been interacting with the principal district judges and district judges on a day-to-day basis, taking clue from them as to how to go about things, the court proceedings soon after the restrictions are eased.
Thank you, sir. So, what do you have to say about, especially using video conferencing, and how do we imbibe it so that we can, when we prioritize cases, this could be an added advantage, or how do you see?
I would like to add, for example, suspension of sentence in criminal case, suspension of orders in criminal revision petitions. They could be easily done with video conferencing. It may not be that difficult also. Lawyers can also, if the High Court permits, even filing of written statement, subjections could be through email also. Email also.
Yeah, thank you, sir. Thank you. So, Dhruti, yeah, I mean, I will come back to the previous question that I had asked
Yes, yes.
about the video conferencing and prioritization. What do you feel?
No, I would add into something what sir has already covered up major part of it. Like, I would say, for example, take it a case of a child abuse, take it a case of a bail, take it a case of a anticipatory bail. Those are the matters which can be sorted by and can be disposed of by a video conference. Not necessarily we need to wait for a adjournment, and not necessarily that we need to wait for dates upon dates that we need to come to the court. And for example, I'll tell you a classic example in cyber law. The moment you give a complaint online, right, for cyber crimes, a woman is abused, for example, and she's trolled. She gives a complaint, so they themselves take the mechanism to address the complaint and make a FIR lodge if needed to the police stations of these things. So for this matters, we need not file the criminal proceedings, etc. We should know what applications can be done online, where the matters can be disposed of online. So you avail those mechanisms firstly. For everything, you need not knock the doors of the court. So with VC, with video conferencing, this matters which are of a priority basis, like for example, mutual consent divorce. We do not go to the matrimonial courts for that. Online VC system can be worked out. Three times a hearing happens, a divorce can work out. But naturally, then you have to see and test out which matters really need court hearings. Not every matter can be evaded off because video conference options are there. So for civic body matters, for example, demolition matters, dilapidated building matters, not necessarily that over a VC it can be done, over a video conference it can be done. There is a physical hearing needed, the antiguities of what it is, what the photographs are. So all that things cannot be shown over the phone or over the conference with this. So we need to bifurcate and segregate that. And the judges would be the best judges to decide which matters can be decided on VC at their assignment levels, and which can be decided on a physical court hearings.
The next. Oh,
Sandhya?
yes, sir.
See, according to me, video conferencing is an exception to the general rule. Exceptions can't be there for a long period. Especially in criminal cases, video conferencing can be used only up to the framing of charges. Because ultimately, Article 21 of the Constitution is involved, whether it is the right of the victim or the right of the accused. For example, if one were to confront a document in terms of Section 145 of CR Evidence Act, that can't be done. That can't be effectively done in a video conference. If demeanor is to be recorded, the lawyer appearing either for the prosecutor appearing for the complainant or the advocate for the accused can't view it properly and request the court to observe the demeanor and make a mark in the order sheet. These are some questions. See, ultimately, we will have to revert to the physical code so far as recording of evidence is concerned. Civil Procedure Code itself proceeds for cross-examination of witnesses by commissions also. Wherever it is possible, such commissions must be encouraged by the courts, and thus the physical presence of the parties can also be dispensed with.
Okay. Thank you. The next point of the discussion is, now that we have a lot of video conferencing, I understand that it's not the most feasible in certain evidence recording, when it comes to evidence recording in certain cases. So now that we have the video conferencing, what is the impact on open justice as it is? I mean, in the sense of, do we have to ensure that there is going to be live streaming of the cases? What is your view on that, Dhruti?
My view on live streaming is if you go to Swapnil Tripaঠি's case in the guidelines for some constitutional matters, if publicly shown and maybe a public interest litigation matter, which anyways the public at large would know, then that is encouraged. We are not going to say let's not have this live streaming. Anyways, it's going to be coming in the paper, but very sensitive closed door matters where I think live streaming would not be appropriate many a times. For example, some confidential hearings are there, and thankfully we don't have those guidelines where live streaming would be permittable for those sort of matters. So as of now, live streaming is acceptable. From a lawyer's point of view, I look at like from the two angles. One angle, that if I have to know in my mind, for example, that I'm going to be live streamed and watched by everybody, I'll be more prepared. I'll be more confident to give more quality work. But the other part of it is, sometimes there could be a subconscious pressure where I won't be able to perform that well because I know that people are going to watch me, and sometimes some things that said in the lighter humor or something said in the court would be a mockery at public at large. So we have to be very careful of what we submit then. And obviously that pressure building will always be there amongst the lawyers, amongst the members at bar, everybody, that whether we will be watched by everybody and judged by everybody, how we perform, or whether our judgments and our deliveries of justice system will be more transparent and more better. So it's a question to be tested out. That's my view.
Back to what Dhruti has just observed is that the caveat is the lawyers must also come, most of the lawyers must come well prepared. They must cultivate the art of hitting straight on the head of the nail in major substantial cases which do not involve intricate questions of law and facts. Order 18 of CPC, 18(1)(d) mandates the civil courts even to ration time for the purpose of arguments. The civil courts have even the power to direct the parties to file written submissions with concise heads also. That is the power granted to the judges under Order 18 of CPC. These are things which I think our judges in the trial court will make use of substantially, and lawyers should also, unless a case really involves detailed argument, they must also try to help the court in addressing the exact issue and enabling the courts to come to an appropriate conclusion. And especially in constitutional courts, most of the judges dictate in the open court, and they are known for brevity. They will pass as brief orders as possible without compromising the quality, and thus they cater to the needs of the parties. You know very well, especially in admission matters, within a paragraph or two paragraphs or within a page or two, the whole case will be summarized and a decision will be taken and an order will be passed. That's how young lawyers, they must learn from very senior, very lawyers who are adept in serious cross-examination, who have done a lot of work in the trial court and also in the appellate court. They must enable the courts. Ultimately, it is strengthening the hands of the judiciary as a whole.
Thank you, sir. The next point is, because of the pandemic, what has happened is that there have been a lot of issues that have come to the forefront that we didn't previously notice. One example would be the rights of the migrant workers, and then another would be, increase in the domestic violence cases. So with this in mind, we also have legal aid all across the country. What is the best way for us to galvanize legal aid? How do we leverage legal aid? Dhruti?
Yes. See, I would look at it as since I've personally been getting a lot of calls about domestic violence, help, etc. and all. So from the legal aid point of view, I think if there's a public notice or public at large would know that, that there is legal aid which is going to help people at large here, where advocates are impaneled with them. We already have impaneled advocates in Bombay. So if a tab otherwise is created on the High Court website that if anybody needs legal aid facilities and help, lawyers, your list of lawyers are listed, they can help you, or maybe through a telephonic conversations, or maybe through a telephonic consultancy, or write an email to the lawyers with concerns with the legal aid. Then many matters like this could be resolved, where people who are eligible to take and avail legal aid services would benefit you. And lawyers would also be active in their work. It's not that you're just sitting idle in your home. Such matters are increasing if legal aid takes a public notice given out situation, because today courts are not working. So not everybody knows that legal aid is existing here. Public at large should know. So maybe a public notice given that legal aid is here to help would probably help. That is my suggestion. That's all that I would like to carry it with.
It's a very relevant suggestion, as Dhruti has pointed out. I add to that, all legal services authorities and committees at the district level and the taluka level now are well equipped. They have their own buildings, ADR buildings. The principal district judge himself is the ex officio chairman of District Legal Services Authority. Senior most judge in the taluka headquarters is the chairman of the Taluk Legal Committee, and each district legal committee has in Karnataka has a judge, civil judge, cadre judge, who is the independent member secretary. Therefore, this is high time that effective legal aid to be given, and it must be effective legal aid to the poor, and it should never become a poor legal aid to the poor. It should be an effective legal aid in terms of Article 39A of the Constitution of India. And I'm very happy to inform you that in Karnataka, many legal aid clinics have been working 24/7, monitored by the State Legal Services Authority and District Legal Services Authorities. There are a number of paralegal volunteers working throughout the breadth and length of the country. They must be taken into consideration, and I think Karnataka High Court is taking the assistance of paralegal volunteers in the matter of filing, assisting the lawyers to file, and ensuring social distance and other things. And such things would go a long way. And the people who suffer violence at the home are the neglected people. They really need effective legal aid, as Dhruti pointed out. Some mechanism, some more vibrant mechanism need to be adopted in order to disseminate this fact of legal aid being available to the poor and needy.
I think that's absolutely well put, sir. I mean, legal aid shouldn't be poor legal aid for the poor. It shouldn't be given for the sake of, just extending legal aid. So that's, I think, a very well-crafted point there. So moving on to, when we eventually move to physical hearings, that is going to happen. I mean, so when we move to physical hearings, judicial time is already very precious. I mean, now with the extended lockdown, we will have more cases as well. So we'll have to concentrate on a few things that probably we didn't really take notice of. I mean, listing of cases. I think specifically we need to probably revisit how we list our cases because in this time we have social distancing norms, and also, how do we ensure that lawyers we balance this right of the lawyer to present the case vis-a-vis making sure that they adhere to time slots, because that's going to be very important, adhering to time slots. So, Justice Chandrashekhara, your thoughts on listing and making lawyers adhere to the time slots? How do we go about it?
Yes, before listing, probably till entire lockdown is eased, with the consent of the lawyers. If it is an ex parte order, no problem. The lawyer who has presented, he must be intimated well in advance so that video conference can take place, and he is heard, and suitable order is passed. Where parties are already have put in appearance and some urgent order need to be passed, lawyers, as I have already told, that they must argue as briefly as possible, hitting straight on the head of the nail, and enabling the courts to pass appropriate orders, either order of stay, order of suspension, order of granting bail, and when the restrictions are eased, and there will be a lot of spurt in criminal cases also. Police will also have to grapple with the number of criminal cases, and till 40-45 days there were virtually no accidents. There will be huge accidents because of the vehicle movement and movement of people. There will be a lot of cases from different angles, and I think it's a question of only a few months. We can definitely overcome all this with the active assistance of the lawyers, and lawyers should also enlighten their litigants as to whether they need to appear before the court, and if presence is not required, they must tell that no, you will be called upon to the court when your presence is absolutely required. Please bear with us. This is how a new phenomena will have to be evolved.
Dhruti, your thoughts on that? I mean, you mentioned the Supreme Court draft guidelines as well. I think if I remember right, the Supreme Court draft guidelines also specifically mentions how they're going to focus on listing only particular matters in different work sessions, and lawyers will be given time slots. Your thoughts on that?
My thoughts are like the way it is drafted, it's pretty, looks like a very practical approach. So, for example, I would also add something more to it. Like we mentioned, a lot of matters in urgency before the court. That's where the crowding happens. So, if instead of mentioning, we get away with it, and like right now, what we are following is a precipice system email to the registry of the court, and then they are listing it. If that continues, and for urgent matters, if matters are to be listed, a separate court bench is also set up where matters can be heard. Things could get better and crowding could be less. The whole concern is crowding. The court should not be overcrowded. The thing is, the matters should go on. Listing of the old matters, backlog should also be taken up on board, to the new fresh matters, to the urgent matters. So dividing those three into different segments, I do see that it is practically possible if proper care and notion is taken, like we see in the Supreme Court guidelines. I think if that is going to be practically worked out, it could be a testing factor, and maybe we can really succeed in that method. That's all I will point out.
I would like to add to what Ms. Dhruti has said. See, the state bar councils are statutory bodies. The chairman of the bar council is the leader of the bar. So the state bar council should write to all the bar associations, both district bar associations and taluk bar associations, emphasizing the importance of social distancing and avoiding crowding. And they must convene meeting of all the presidents and executive committee members if possible through virtually, and tell them that these are important things to be kept in mind. And for example, Bangalore Advocates Association, which has more than 16,000 members as advocates, and I think they are also cooperating with the schemes formulated by the High Court, and they are also sitting, and they are also taken into consideration. Their views are also taken into consideration. And if advocates have some good practical suggestions, they can formulate it and present it through their representatives to the High Court or the principal district judge. And if they are well merited, definitely they will be taken into consideration. It is not as though the judges themselves frame guidelines. They will be very happy because they were also advocates at one point of time. They will be eager to know practical suggestions from the members of the bar.
So, I mean, now that we are discussing overcrowding, we are looking at it from the perspective of the lawyers, particularly. But then we know that certain matters warrants the presence of clients. Particularly what strikes me is the family courts. You have a lot of clients coming in. There's going to be a lot of overcrowding in the family courts because you have both parties present, and you have, anywhere the listing might be from 40 to 80 matters per court even. So there's going to be a lot of challenges that, especially at the family court level and other courts where you would have party presence, a heavy party presence. So how do we navigate this aspect? And will video conferencing be a groundbreaking mechanism, at least when we apply it to certain matters like this, considering the situation now? Dhruti, if you want to go first.
I'll take the lead if sir doesn't mind in this to go first. Yeah. See, basically, what I would particularly just take an example from African Arbitration Academy point of view. This is a little different, which I like to correlate here of what we could do to reduce the evidence part of it, the crowding. What the protocol there is pertaining to arbitration. If that can be used here in India and in our systems of courts, it could be very well standardized. If video conference, evidence recordings can be tried and worked out, then we will be reducing a lot of crowd coming to the court. In the sense, now you will tell me, when I am giving a cross, what if some third person is prompting me? What if some fourth person is prompting me? So the screens, the way the protocols are made, the screens are so clear that one can see, visualize it properly, that nobody else is there. The answers are given very straight, looking at the screen. So that arrangement needs to be done. Because today, many matters, particularly in family courts, a lot of this evidence leading and cross-examinations and absolutely those things go on where people's presence is needed. But if we use those protocols, the guidelines which we can also frame of how this cross-examinations through the VC can be done in a systematic way, then we can utilize it, use different countries' methods of how other courts are also progressing it. I'm sure then the crowding and arrangements can be organized in a very well way. Because I tell you, these matters are never going to end. The domestic matters, the matrimonial matters. And the litigation there is going to increase, not really decrease so quick. So we need to have a fast track mechanism. Like, for example, I gave my example of mutual consent divorce just earlier. You don't need to come physically to the court for that if you can digitally sign out and things are done. So that way, for those matters where critical examination is needed, then court can probably decide, no, come to the court and physically be present. Otherwise, if video conference can work out, it is a very good mechanism to reduce the crowd. And even audio recording can be a good option, like we have it in USA. Not necessarily we need to have the screen seen also. But in few matters, a party wants to see with enthusiasm. Look, nobody's prompting A or B, they're answering directly to the point, right? and with a time limited spot should be given so they don't get more time to think. It's on the spot deliveries. So if we try those methods, it can work out.
So, sir, what are your thoughts on this?
But let it not be construed as contradicting Dhruti's statement. See, in an eloquent judgment, Honorable Supreme Court in Afghan infrastructure case has specifically laid down that in all family matters, before objections are filed, they are to be referred to mediation centers. Almost all the courts have no mediation centers. In Bangalore, there are more than 8 or 10 family courts. If and they must be referred to mediation. So the moment they are referred to mediation, there will be a lot of rush because it's a law laid down under Article 141 of the Constitution of India. We can't ignore because with a lot of intention that judgment is written by Honorable Justice Ravindran, keeping in view that before the stand of the parties hardened by way of filing a written statement, they are referred to the parties. Even in cases of consent, an all-out effort is to be made that there is no other go except to award a divorce by consent. The mediators must be fully satisfied that in spite of best efforts, the parties are at loggerheads and there is no other go except to recommend for a decree by divorce by consent. So this is a very important area which we'll have to keep in mind. How to go about it, it needs a lot of deliberation from the judges sitting in the family courts, lawyers practicing in the family courts, the mediators attached to those courts, the High Court. This is a very important matter because this is a step in aid under Section 89 of CPC. Because mediation is the panacea for all disputes involving matrimonial disputes. That it is a question of the custody of the child, matter between husband and wife regarding restitution or divorce or anything. This we have to think over and online according to me, because the mediator will have to get the parties, speak to them, and he has to introduce himself and he has to create a lot of confidence in those parties because for the first time they must feel, because court atmosphere is something different. See, all legal processes there, but here is a platform where other than the parties, persons who can very well contribute for an amicable settlement can also be summoned, can also be called, and therefore this requires a lot of thinking. And wherever it is easy, we can have it by way of video conferencing, but this is a very important matter we cannot easily ignore. We have to keep in mind the law laid down by the Honorable Supreme Court in Afghan infrastructure. We have wonderful mediators here, but we can't have too many persons present in the mediation center. It's 1 or 2, it's okay, all right, they will do it. We'll have to take mediation centers, like Delhi Mediation Center, Bangalore Media. There are big mediation centers. They can help in finding an appropriate solution.
Okay, thank you. I mean, while we are at, I think Dhruti brought up this point of audio hearings as well. So predominantly we focused during this lockdown while embracing technology on video conferencing and e-filing mostly. So what other mechanisms, you brought up audio hearings, apart from audio hearings, video conferences and e-filing, what other mechanisms do you think that we should focus on to improve justice delivery in general?
I get your question. I personally believe e-filing formation and the guidelines are already framed by the Supreme Court, and we have it in hand. In addition to that, I will say something about translations. Many times what happens, we have to wait for official translators to give us the copies of the translations in hand, say for 1 week, 2 weeks, 15 days, because people are not equipped with. So why not invent or have the software available incorporated in our system where they can auto translate it into the various languages? We have language tools also available. So if we get those into a testable factor with technical experts, which softwares could be best, where we have to use less time to put it for translations, and within a fraction of half an hour or 40 minutes you get everything translated right in the language you want in. so that many a times even parties, if they don't understand the language which the opposite parties don't understand, it's very convenient for them to get it in copy. Plus the benches who are hearing the matters also have this additional concepts, click and go system, that they can get translated English versions of it immediately if they want. Because in Maharashtra, in subordinate judiciary, many applications are made in Marathi. Not that every lawyer would know Marathi to that detailed extent. If a translated copy can be available in a short, quick go by a software changeability being this, then it's easier for them to argue. This is something that I would like to add. Apart from that, there are also e-filing protocols which we need to follow, because many a times, if our clerks are not very well equipped with the process of how to file, we really waste a lot of time doing it independently as lawyers. So we should train our clerks who are associated with us to know how to do e-filing, because not everybody knows computers, though they know how to take a printout in a one-click go. But we need to invest time and we need to train them, sitting with them. Look, this is how we file. Give them precedents and examples. First 2-3 filings we should do on our own, so the clerks can also learn, and then we save our time. Just give it to them; they will file it for us. So this is hand-in-hand mechanism we need to use if we are going to go virtually, and we need to go paperless someday. Then this paper formats of filing heavy compilations, giving it should also end. Services should be done online to more practical way. This is an acceptance and mindset changeability we need to adopt first. That's all that I would like to put in here.
I think that's an important point you brought up there, because more often than not, we don't pay attention to training all the stakeholders in the system. The clerks are going to be your front runners when it comes to filing. Most offices still have clerks for the filing as well. So you need to ensure that they are factored in when we are trying to make these changes as well. Justice Chandrashekhara, if you would like to add.
May I add one thing, madam? May I add one thing? See, after post-lockdown period, all the courts can't be opened simultaneously. Let us assume that there are 5 courts in a complex. All the 5 courts can't run simultaneously, because because of the expansion in the system of courts, the staff is limited. So if all the courts are open and cases are listed, there will be heavy rush. So if there are 3 courts, they must work alternatively. One court today, day after tomorrow. So that is how, and minimum cases which necessarily to be taken up on. And the skeletal staff available would work for receiving the cases, scrutiny, payment of court fees, payment of summons fee, everything. That will take care. Otherwise, if courts are opened simultaneously, there will be huge problems, and we must try to avoid this. This is one thing which we will have to keep in mind. And please, once again, I reiterate that recording of evidence in the physical court is the normal rule, and video conference is an exception, and lawyers who are well trained in examination, in cross-examination, will vouchsafe it. And this also keeps in providing good stuff to the court in order to arrive at a proper conclusion. You wanted to ask some question, madam? Please.
We've discussed a lot. We've discussed a lot on digital tools that we are using. Most of our
Yes.
discussions have been factored around video conferencing, e-filing, and
Yes.
to some extent, audio hearings as well. So in this context, I think we sort of touched upon the digital divide as well, with lawyers face, that litigants face. So how are we going to address this digital divide? The system needs to progress for everybody at once. It can't be just for the privileged few who have access to digital
Yes. Yes.
technology. So your thoughts?
Ms. Dhruti has already covered this point. Majority of the lawyers are suffering because of this divide. Bar association should be the front runners. They must prevail upon the elected governments to provide funds. There must be effective video conference system. There should not be any difficulty in organizing such systems within the court premises, that is within the premises of the Advocates Association. And this is an opportunity for those who are not conversant with this digital system to get themselves and bar should take up the lead, and judiciary will also help because there is a computer system, there is a computer network in the high court itself, and in each district court there is a computer specialist also. Their help can be definitely taken, and the computer committee of the high court is headed by a very senior judge of the high court, and they will also be interested in helping the community of lawyers who are suffering because of digital divide, and they should have separate platforms, separate rooms, and government should also give priority. It gives priority to various aspects. It's right. This government should also give priority to this thing, and the leaders of the bar in the district level and the state level should take up this cause with the elected governments and get suitable funds and infrastructure. I think governments will be very happy to assist the members of the bar and who are suffering because of this digital divide.
Dhruti, do you want to add anything to
Yeah, I
this?
want to add three things to this, basically. This is the, like Sir has overall covered everything, but to just add on, three important points is, firstly, if I am a law student in college, interdisciplinary training of law and technology should be made compulsory. Because if I don't learn at my base today, I will be really lethargic to learn later. And that's where we feel like, oh, now I really have to learn. So you must know, if you're in the pool in this profession today, technology is something important. And that training must be given from the ground level of law school. That's first. Second point is, even lawyers who are not well equipped with technology, many lawyers would not have facilities also. There should be a system created where, technical experts can be, hired by them at a low cost price, or maybe hourly basis, like we have stenographers who come and type. So their needs can be sorted out. Just because some people cannot really know technology to a great extent doesn't mean things can stop. Things will move on. We need to avail options who are trained to get them rolling with us. So it's that, like, if I am a good counsel here today, not necessarily I'm a good technical person. So I should have technical staff with me. So what I'm trying to say in this digital revolution and this digital world that we are going to accept, and we have to, even if we don't want to, we have to somewhere go to this forward situation to have a supplement to our regular hearings that we are doing. We must have this sort of staff available with us, friends helping us in this scenario. And sometimes if you think like we can't get see, for example, computers have come in 1990s. Now, so much have it changed till 2020. So we've got staff trained. Today, everything is available online with a click and go. So this way, cannot this technology and hearing also evolve and get to a better flow? It can. For that, we need to have people putting in some investments together to have good computer system in their own offices also, because many a times everybody cannot afford. So some sort of funding, which Sir just said, maybe some schemes can come out that can help lawyers avail it. It can become economical for everybody. It can be share and bear basis also. It's like I'm sharing one software of translations, for example, with 3 of my friends. We can share the cost. It becomes economical. So these things can be made available, and for that, obviously, the bar associations, bar council will have to be participative in it, and I'm sure they will be doing it because we have full trust in the way the system is moving and the way they are working. They're working more harder than all of us talking here to get some conclusive solution for us. So let's look forward for it. And the third point, which lastly I want to close with, that digital revolution will never end. It's always going to go on and on. We need to update ourselves. And updating ourselves is just because now you know how to do e-filing doesn't mean I know everything in the law system. No, there'll be something more. Suggest to the judiciary, suggest to the bar new softwares which you are aware about. Don't hide your knowledge in technology, because today technology has to be open knowledge for everybody. So that's what I'm trying to say. Just because you know something you don't want your colleague to know doesn't mean that you hide it out. Share it with them, train them, help them. Because that's how we all will grow in the fraternity. And it's our fraternity we should be proud of. And it's time to save our time, interest, and money, everything together. Because COVID-19 has shown us a good lesson.
And I will add to this. See, it's very heartening to note that very, very distinguished senior advocates, both at the Delhi level, including Harish Salve and Mukul Rohatgi, our Attorney General, and right up to our senior advocates, they have been speaking on Adhivakta Parishat platform and other platforms on various aspects and highlighting and enlightening the advocates community on various aspects of law and very, very important issues. On this note also, I would like to add that while judges are selected to the district judiciary, some weightage is also given to the knowledge of the computers.
Just one last
Digital
thing.
knowledge,
Can I just
digital knowledge. So therefore, the lawyers, if they know very well, and if they have chances of taking up examinations, it will be very helpful also. And as Dhruti has said, that lawyers community themselves help those who are in a disadvantageous position. And this is an opportunity for them to really help them. And see, they also come to the same forum.
Just one last thing, if I may be allowed, Sandhya. Here we are always talking about digitalism and we're talking about technology, but we have forgotten one major aspect is security. So we should have securities that none of our systems also get hacked. At our offices. So in the sense, what I mean to say is, it's just not that you have to be negligent about the fact that your computer is a go away. It's your business forum. It has to be well trained with securities, IT levels, and also with that level that whatever information is going out from your email ID or from your official ID is your, and you are accountable for it. You cannot come with a conclusion, oh, my junior just sent it, or my clerk just sent it. An error made by them, you are accountable. So lawyers have to be vigilant as well in this digital technology. That's all I'm trying to put forward.
Thank you, Dhruti. Thank you, sir. I think that was quite insightful because we obviously, like Dhruti mentioned, it's very important to engage the law students. We often forget that's where change would start as well. So that's a very important point there, as well as cybersecurity, because we are all talking incessantly about video conferencing and e-filing and technology in general, but cybersecurity is going to be an important aspect that we have to factor in as well. So with that, I think I will open the floor for some questions. I already have some questions here. I'm just going to take a minute to. So the first question we have is from Justice Chandrashekhara. He says, post-COVID, is it possible to hold mega Lok Adalats? If so, in what mode can we do this? Justice Chandrashekhara, if you would like to address that.
So I think organizing mega Lok Adalats, which necessarily involves the presence of parties, may not be advisable for a few months. I think the National Legal Services Authority might have taken some decision and might have communicated to the state legal services authorities. Wherever presence of parties in large number is required, it has to be avoided. And instead of that, in small cases where parties' presence is not required, for example, motor accident claims cases, death cases, no intricate questions of law and facts are involved, these check bounce cases, lawyers can, lawyers can definitely come together in the Lok Adalat and give their opinion. And if after some sort of, say, consensus is arrived at, parties can be called separately and their consent can be taken and awards can be passed. I think it's not advisable to have mega Lok Adalats.
The next question is for Dhruti here. So it says, given digital illiteracy for simple matters, do you think audio hearings can be done as seen in England and Canada? And if so, if we are going to be doing audio hearings, what barriers do you think we'll have to overcome? What are the things that we'll have to bear in mind?
It's a good question because it can be correlated with video conferencing. I'll tell you how. For example, we have good bandwidth system from the court side of it. From the lawyer's office, there is a breakdown in bandwidth. What do you do then? Like you can have this facility additionally added that you can have an audio conference tele number given wherein the hearing should not stop. So the moment if the video goes off, if internet goes off, at least this audio connectivity can make the matters go on. So there should not be a pause and adjournment on that ground because many a times lawyers may just say, look, the video conference is not working well, so now we need adjournment after getting the matter heard to halfway. So if audio facility in addition is added and connected, it will be very good. So there won't be a possible option. Matters will go on. So there has to be a tele audio helpline or line connectivity where with a click of it we can connect through a phone also and continue our arguments. Like we have it in England and USA, we can have this supplement. A thoughtable process can be worked out on this.
Added to this, ma'am, Sandhya, I would like to inform you that Karnataka Judicial, I am a regular resource person for Karnataka Judicial Academy. Karnataka Judicial Academy has been organizing video judicial education through online for all the trainee officers, newly inducted officers. They have not, and every day 3 to 4 classes are taken, and those who are interested in coming, they can go to academy itself or they can address from their homes itself, and arrangements are being made, and it's an ongoing process, no glitch in it.
The next question we have here is again Justice Chandrashekhara Joshi. It says, an important step to be taken due to COVID is to reduce the footfalls in courts. Can Section 205 of the CRPC be applied in default to all criminal cases? What do you have to say to that?
Definitely. Wherever no criminal case will be taken up for trial unless it is absolutely required. Unless it is a case of custody criminal case where major portion of the trial is already over. Otherwise, Section 317 of CRPC exemption for the day, 205 exemption till the recording of statements, they can be liberally allowed. I think our judges will liberally consider those things because they also know very well that there should not be too much of footfalls in the court.
So, I mean, I would also like to I just had a thought about the audio hearing question that we had before this. So, Justice Chandrasekhara, audio hearings, I mean, we can use it for particularly, maybe extending injunction orders and, very certain simple issues as well. But I think the issue would also be how do we ensure that the person on the other line is a legitimate person? So what do you feel about
It's a system which can be definitely applied. I think there may not be much difficulty through audio. Video conference, I think many a times there may be some glitch if there are too many persons. I think audio may not be that difficult. For the limited purpose, as you indicated, it can be used.
So we have yet another question here.
May I add one thing to this? I just thought of an additional affidavit can be scanned and said, I am the person I have been speaking and this is it that I have been spoken. If you find out otherwise, then I'll be responsible. Maybe. That can be a step.
Added precaution there, a layer of precaution.
Yes. Or penalize them then.
Either way. We have a question here from Shantanu Council. It says the government is responsible for a very large number of cases. Is this the appropriate time for the government to review and maybe drop or withdraw as many cases as possible? Maybe even settle, I don't know, we've been talking about ADR as well. So,
may I know to whom the question is addressed?
It doesn't have, I think anybody can answer it. So you can go first as well.
Oh, okay. See, there is a national litigation policy of the central government. Each states have litigation policy. I have always been advocating that in majority of the cases, especially in the High Court, state, whether it is center or the state, are the parties in large number. For example, let us assume that a mandamus petition for mandamus is filed. The relief is direct the land record authorities to survey in spite of our application being pending for more than 6 months. No financial burden is involved, no policy decisions are involved. Such cases, even why to allow the court to pass a considered order? Nothing of that is involved, like the policy decision or the financial implication. Such cases can be grouped, and there can be a committee formed under the chairmanship of the Advocate General or Assistant Advocate General, Additional Advocate General, and there can be some responsible officers from the government. They can identify such cases and make suitable submissions and thereby lessen the burden on the court. See, as a judge of the High Court, I have also seen, as a judicial member of the Karnataka Administrative Tribunal, also see in many cases, the reliefs will be virtually of not that serious nature. Why can't they be considered from the government side itself? And it saves precious time of the parties, precious time of the court, and unnecessary burden on the judiciary also. Judiciary's time is very precious. Lawyers' time is very precious.
Dhruti, you want to add something to that?
I think Sir has covered on quite a lot of things. There's nothing that I want to add beyond what Sir has said. He's not left to go out for me to say anything. Yeah.
Okay. So we have yet another question here, that is from Arunav. It says, what steps can the judiciary take to ensure that ADR is used and tried effectively by both lawyers and litigants?
Can I answer this?
Sure. You can go first.
So may I answer this? First, I'll take it.
Please answer.
All right. See, basically, judiciary, anyways, has been playing an important role in appointing mediators and arbitrators in court annexed proceedings, basically, like even in appointing an arbitrator. So now, if this entire system, as I said in my opening and my first answer, that if online ADR system is formed, where chief justices and the judges participate in helping that form, then definitely there will be generation to work, there will be generation to system where there will be trainings also given through the court, and people will get economical benefits of it, as well as they'll learn. Online trainings can also be started off. So this is something we can think in this lockdown situation, if at all, this can be taken on a serious note, because this is something we see in the near future. This is what it's going to be like. So I've already answered that in my, proceedings. So if you want to add something, you may.
Madam, I would like to add. See, before the introduction of Section 89 of CPC with effect from 1/7/2002, Order 32A of CPC was already in vogue. It is already in vogue, even now also. Order 32A mandates that in all cases concerning family, judge shall make an honest effort to conciliate between the parties and for a settlement. So that is a mandate also. It is further reiterated in Section 89, and it is made clear in view of the drafting anomaly found in Section 89 and vis-a-vis 10A, Order 10A of CPC. And Supreme Court in Afghan infrastructure has said that it is the burden, it is the mandate of all the judges dealing with civil courts, original suits, to persuade the parties to opt for one of the modes. To persuade the parties, they must take lawyers into confidence. Without lawyers, there can't be any persuasion of the parties. Therefore, it is a process, and I think Section 89, if it is implemented in its real sense, it will be a game changer in the whole judiciary, especially in the trial courts, I think.
We have one last question here. I think it is again from Justice Chandrashekhara Joshi. I think it says there are 25,000 courts in the country. Live streaming even 50% of the courts would be difficult due to infrastructure and other constraints. What is the solution?
No, it is the duty of the state governments to look after the infrastructure. For example, in Karnataka, whatever proposal is sent by the Honorable High Court of Karnataka to the government, it is usually accepted. In very few cases, it may be deferred, that's all. It's no question of rejection itself. And you see, when I was the director of the mediation center, I was called upon to assist assist the High Court in establishment of Karnataka Arbitration Center. And a single window was formed by the then Chief Secretary, and the Finance Secretary and the DPR Secretary would be present, and decision would be taken, and the next day the orders would be in our hand. This is how if the governments do not consider this as a priority, can't help. They must see, vibrant judiciary is a part of effective democracy. So courts play a very important role. It is the duty of the governments, whether at the center or the states, to assist them. That's it.
I'd like to add here. For example, now in this situation, we have the necessity of common infrastructure technology throughout the country, which if government can consider and come out with some plan where every court would have a common pattern of bandwidth, a common pattern of technologies, a common software use, instead of every state deferring it, then it could be in a better platform. better working
No,
style.
no. I think there is a E committee in the Supreme Court also.
Yes, yes.
They coordinate with all the state level committees headed by senior judges. I think they will coordinate, and I think
Yes,
they're
this is what
seriously
we put forward.
thinking of evolving a common system.
Because this would all need cost, sir. I was on the cost factor. This would all need heavy cost. So
Yes,
judiciary would definitely put forward the proposal. So
yes,
government has to participate in, bearing this cost, if at all.
yes,
You know, this is something we need to really put it together in a streamline and in a proper line. Which obviously
yes,
our judges are doing a fantabulous job for, like, forming this committee, taking suggestions.
yes.
Our bar council members as well as our, associations are working too hard for getting everything comfortable for all of us. So let's see what is best. But government would need to really give us that support system as well when we require it.
No, the Union Law Minister himself is
Yes,
one of the champions of e-courts. He has made expressed his opinion in this regard. I think central government and most of the state governments, they come forward. It is
that's really nice then.
they have to take use of this.
I think with that, I mean, our question session is pretty much done. I would request if our panelists have any closing remarks to make before I conclude the session.
So you start.
Yeah,
This has
closing
been
remarks from
this has been a very meaningful session. We were I was especially very happy to join this along with a very experienced, very enlightened panelist, Ms. Dhruti of Bombay. And I am also happy that DAKSH has taken lead in organizing this. Lawyers, judges, litigants. It is the joint duty, and a joint exercise must be done to get over this extraordinary situation and come back to normalcy, and also to learn to live with this, and also to learn more on digital side and its application in the judiciary to the maximum extent. Thank you. I am grateful to the viewers for having logged in, and I am also grateful for the organizers, and grateful to the co-panelists who had assisted, who has assisted me. Thank you.
I would firstly like to again repeat and thank Daksh that they've done fantastic job for organizing this entire webinar, because in the process of our discussions, the ideas were churning in more and more, because our panelist Justice Chandrashekhara was also fantabulous in his points out, which gave me a churning thought process to answer from the bar point of view also. And also our viewers who have patiently heard us and have been with us throughout the session. So my closing remark is basically three things we must take forward from here, which in my view would be comforting on whatever preparations I had done for the webinar. Firstly, that let's introduce the softwares for translations. That would be very, very important. Secondly, educating our own law students from the school level to the university level, what I mean to say, to have law and technology as a mechanism. And third, which is going to be most important, rather the first would have been this ADR online systems, ODR, which would be a real platform where all of us can start really pushing our clients and convincing them towards the dispute resolution system, which we have tried in the past, but not to a great extent. We should do it harder now, because this is where we will get work. They will win out the matters in a shorter time than actually the exercising of litigation. Judiciary itself will reduce the workload. So with this closing, thank you very much. I've enjoyed completely with each and every one of you all. And this virtual act of webinars have really been enthusiastic for all of us. Let's keep going. And Daksh, all the very best for a wonderful job that you all are doing together. Thank you once again.
Thank you.
Thank you, Dhruti. Thank you, sir. I mean, thank you, all the panelists. I mean, you've been very generous with your time and effort, and it's been a phenomenal experience for us to have this idea exchange as well and discuss, how digital technology will impact our justice system. And as sir rightly put, a vibrant judiciary is a big part of the democracy as well. So it's important for us to have these discussions as well. Thank you so much for the panelists. Thank you for all the audience members who tuned in and was watching our live stream discussions today, for those who posted questions as well. Thank you. And if I mean, if you're interested in video conferencing and certain topics that we touched upon today, including digital technology, DAKSH publishes a lot of research on digital technology and engagement with the courts. More recently, we came out with our white paper series on the next generation platform, as well as one of our papers was the video conferencing aspect of it as well. So these are all available on our website. It's accessible by the public, so you can check out our website. We are also on social media, Twitter and Facebook particularly, so you can follow our work there as well. Thank you again, everyone. This has been an incredible opportunity for me to be a part of this discussion and moderate this discussion as well. So thank you again, Justice Chandrashekhara and also Dhruti. Thank you so much.
Thank you all. And be safe all. See you.
Yeah, everybody has to be safe. With that, I'll sign off.